This is an appeal in the matter of Stratford Development Partnership and another, and Triathlon Homes LLP and another.
Mr. Selby.
Good morning, my lord. I appear with my learned friend, Miss Crampin, who's sitting behind me. My learned friend, Mr. Nissen, and Mr. Letman appear for the first respondent, who I'll refer to as Triathlon. Then my learned friend, Mr. Polly, at the end, he appears for the second respondent, who I'll refer to as EVML. And then my learned friends, Mr. Walsh, Ms. Chorley, and Mr. Miller appear for the Secretary of State. Before I get into the weeds of the appeal, as it were, just a few points of housekeeping. First, as you will have seen, we have permission to appeal in respect of 3 grounds, but we're not pursuing ground 3 for the purposes of today as a result of the amendments introduced to the Act by the Leasehold and Freehold Reform Act 2024, an act which I'll refer to as LUFRA for simplicity. When I make my submissions, I will first address you on ground 1, just and equitable, and then I'll address you on ground 2, which is what I think what's been referred to in the earlier hearing as a retrospectivity point. Secondly, although the focus of this appeal will be on the decision of the First Tier Tribunal, you will have seen from the procedural history that this is formally an appeal from the decision of the Upper Tribunal, because during the course of the first instance hearing, it was recognised that the case could not be transferred to the Upper Tribunal. And you will have seen there's been a quasi-leapfrog procedure that we've adopted with the cooperation of the court to enable this case to come before you today. In this connection, although the decision of the Upper Tribunal was made without a hearing and without hearing any arguments or submissions, the parties have agreed that they will be entitled to argue the appeal before this court fully, as if the appeal to the Upper Tribunal had been argued fully before the Upper Tribunal.
Yep.
And just for your note, that there's a letter in this connection dated 4th of April 24 in the core bundle at tab 14.
Yep.
Thirdly, you should have seen the agreed timetable.
Yes.
Which involves me addressing you this morning and until approximately the middle of this afternoon.
1 hour and 7 minutes, I think.
Yeah, I wasn't sure how precise you will hold me to that, but I'll do my best. Then you'll hear from my learned friend Mr. Nissen until about lunchtime tomorrow. Then Mr. Polly and Mr. Allison tomorrow afternoon, and fine. Sorry. Oh, sorry, Mr. Walsh. Sorry.
Yes.
I'll reply on Friday morning, and then of course you've got opportunity to hear from the parties to the Adriatic appeal, ideally before lunchtime on Friday.
Yes.
In terms of my timetable, I intend to address you on ground 1 this morning, with a view to finishing ground 1 shortly after lunch, and then I'll address you on ground 2 this afternoon.
Yes.
So, ground 1, just and equitable. Can I start by orientating you by reference to the remediation contribution orders that were actually made? Why are we here? So that's in the core bundle at tab 12, page 211. Well, sorry, the order starts at page 208. And the substantive part of the order starts at page 210, and your paragraphs 1, 2 and 3 do not concern this ground 1. It's paragraph 4 over the page at 211. Those figures total about £16 million, and they're the subject of this ground 1. As a preliminary point, I should just clarify why ground 1 doesn't relate to paragraphs 1 to 3 of the order, and that is because those first 3 paragraphs are not the subject of Building Safety Fund funding. As you see, the RCOs made involve payments to EVML, not to Triathlon or the Building Safety Fund, and they are payments in respect of what would be Triathlon's share of remedial works cost if Triathlon were charged for it through the service charge. They are not payments in respect of the entire remedial works cost. There are then conditions to the order at paragraph 5. And if I can, I'll come back to A and B, but if I can start over the page with C and D, they are self-explanatory provisions requiring EVML to pay over to SVDP or Get Living any monies it ultimately receives through the pursuit of third-party claims relating to the cost of the remedial works. The context to that is, as you would have seen, is that EVML is pursuing claims in relation to the 5 blocks against Galliford Tri, the design and build contractor for this development. And the intention of conditions C and D is essentially to avoid double recovery. Going back to conditions A and B at page 211, they in essence require EVML to comply with its obligations under clause 5.4.3 of the Building Safety Fund grant funding agreement to the extent required by the GLA and or DLUC. GLA, the Greater London Authority, DLUC, the Department for Levelling Up Housing and Communities, now called the Ministry for Housing, Communities and Local Government. And as you see from paragraph 2 of the reasons behind the RCOs, and that's at, back at page 212, those two conditions, A and B, were included because the reimbursement of public funds was part of the justification for the making of the order. The intention is that the RCOs positively require, I hope you don't mind me referring to them as RCOs rather than remediation contribution orders. They positively require EVML to comply with its obligations under the grant funding agreement. And so that you can understand those two conditions properly, please let me take you to clause 5.4 of the grant funding agreement. So that's in the supplemental appeal bundle. It's towards the back, it's section E of the bundle, tab 3. And it starts at page 192. And you see it's an agreement dated the 1st of June 23, and it's between the Secretary of State, the GLA and EVML. And clause 5.4 is through at page 223.
Sorry, what page?
223, my lord.
Thank you.
And you see clause 5.4.1 is the provision which requires the recipient of funding to pursue third-party claims in respect of the defects which are the subject of the funding. And that includes claims against insurers and any relevant contractors or warranty providers. And then you see at clause 5.4.3 the obligation to account for any recoveries from any such third parties. And the point I particularly ask you to note is that the grant funding agreement envisages a long time frame in which third-party claims may be pursued. You see from the first line of 5.4.3, it has a time frame of 12 years from the date of the agreement. But nevertheless, once those recoveries come in, it requires them to be paid over promptly and net of any irrecoverable costs relating to the pursuit of such claims. So let me now take you to section 124. As I already mentioned, there were a series of amendments to section 124 by Loughborough. So far as this appeal is concerned, nothing turns on those amendments, you'll be pleased to know. And my learned friend Mr. Nissen and I have agreed that as will refer as necessary to the version of section 124 that was in force at the time of the hearing before the FTT, the original version. And that's in tab 5 of the Core Authorities bundle at page 89. And for your note, the amended version is at page 30 behind tab 4.
Just before we look at that,
Yes.
I'm sorry to be so slow. The practical effect of what you showed us in the RCO and clause 5.4.3 is that EVML pursues third parties, Galliford Tri,
Yes.
and anybody else. If it recovers money, it pays it back to the Building Safety Fund, in effect.
Well, no.
It goes to the department.
So the practical effect of the RCOs is, assume it receives money from Get Living or SVDP.
Yes.
It pays that money over to the DLUC or the GLA. So once the GLA has been made whole and it recovers money from Galliford Tri or any other third-party claim, then it has to pay that back to my clients.
But that's only once the Building Safety Fund's been made whole. And the amount of the RCOs is only Triathlon's share
Yes.
of the cost, the 16 million.
Yes.
So that, if the RCO stands, the 16 million comes in from you, goes over to the Building Safety Fund.
Yes.
But that's only a proportion. So
Yes.
30-something percent of the monies or something. Or
I think it's nearer to 50 or so.
whatever it is. So if it succeeds against Galliford Tri, it still has to continue to refund the Building Safety Fund, is that right?
Yes.
And it's only if there's any excess over that it then goes to you.
Yes.
Yes, thank you. Sorry to take
No.
a while to get there.
No, I'm very conscious that I'm much more warmed up, at least at this stage, than perhaps the tribunal is. I'm sure that will invert at some point, but
Thank you.
there we are. So, let me address you first on the purpose. I know you've heard a lot about the purpose of sections 117 to 124 and Schedule 8 of the Act already in the context of the Adriatic Appeal. Those provisions, that set, are colloquially referred to as the leaseholder protection provisions. I know that's a phrase you're familiar with. I don't think we need to go very far to understand the purpose, if we need to go anywhere at all. Section 116 of the Building Safety Act is very clear about the purposes. And we see that behind tab 4 at page 14 of the bundle. You see subsection 1, it tells you that the group of provisions, the leaseholder protection provisions, make provision in connection with the remediation of relevant defects in relevant buildings. And then you see 2B, section 122 and Schedule 8, they contain protections for tenants in respect of costs connected with relevant defects and impose liabilities on certain landlords. So that's the leaseholder protection side of the provisions. those two broad purposes in my submission are interconnected in this sense. While relevant defects have to be rectified, and I would add rectified without delay, the cost of that work should not fall on individual leaseholders who generally either do not have the means to pay for remedial works or do not have the means to pay without substantial hardship. So then when we come back to section 124 at tab 5, we see an element of dovetailing when you come to subsection 2. It specifically uses the word purpose. And the purpose is there stated to be meeting the costs incurred or to be incurred in remedying relevant defects. And when you read section 124 with 123, you see that the purposes of the two provisions are complementary. I don't know if you've seen section 123 before, but that's the provision for remediation orders. And for your note, that's at page 28 behind tab 4. 123 is aimed at providing a mechanism to make someone remedy the relevant defects. Essentially, it's the landlord or the management company of the relevant building. Whereas section 124 is aimed at providing a mechanism to ensure that the funds are in place to pay for those works. So we see that the two sections are a very practical and pragmatic set of measures aimed at fixing relevant defects in relevant buildings. If I can put it colloquially, the message from Parliament is get the work done. And when read with Schedule 8, we see that their aim is to get, we see that, but without placing the burden on leaseholders.
Could I ask a question, please? You took us to section 116.
Yes.
The overarching section.
Yes.
And subsection 2b introduces section 122. Contains protections for tenants in respect of costs and imposes liabilities on certain landlords.
Yes.
I was interested in what the liabilities are. If I turn to section 122, there is perhaps a liability in subparagraph B because it provides for recovery of amounts to landlords.
Yes.
But we haven't actually looked, I think, in Schedule 8, maybe we don't need to, beyond paragraph 10. But I'm just interested in what are the liabilities imposed on landlords by Schedule 8?
Well,
other than recovery, where someone is treated as having paid something they shouldn't have done.
my lord, I'm reluctant to trespass too much on the Adriatic appeal. I know you've had a lot of discussion.
But we've got to read the statute as a whole.
Absolutely. There's been a lot,
so.
and I will, and there's been discussion about paragraph 10(2)(b) about the mechanism for repayment by landlords where they've charged service charge when they shouldn't have done so. But then there's also later on in Schedule 8 provisions for regulations to be issued, statutory instruments and the like, in relation to such matters. And one of those is the LPI regulations that has since been issued, and that is a liability on landlords. Yeah. So that may well be
that would flow from the provisions we've looked at already.
Yes.
But it may be helpful for someone to assist us on what liabilities are being referred to there, because you're going to take us to underground 2 to section 124, and we need to see that in the context of the statute as a whole.
Absolutely, my lord. What I'll do is my learned junior will give me the precise paragraph references that give rise to the LPI regulations, and when I get an appropriate moment, I'll give you that reference. My understanding is that's what it's referring to. And of course, we'll look at the LPI regulations when we come...
Sorry, I have to interrupt.
No, not at all. When we come to ground 1.2.
Can I ask another question? You said a little while ago, and I failed to make a note of it, that the statute tells us what the purpose of these provisions is. Where do we find the word purpose?
The word purpose is in section 124(2) itself.
For the purpose of meeting costs.
Yes.
Thank you.
But the word purpose, I don't believe, is in section 116.
No. Thank you very much.
So going back to section 124, behind tab 5 of the authorities bundle, can I ask you please to look at the definition of developer at subsection 5? And you'll see that to fall within the definition of developer, all you need to be is a person who undertook or commissioned the construction or conversion of the building or part of it with a view to granting or disposing of interest in the building or parts of it. There is no requirement anywhere to prove that the developer was actually at fault before the entitlement to an RCO can arise. The aim of section 124 is not to identify responsibility for the existence of the defects. Now, the word responsible for features in Schedule 8, paragraph 2. But even in that context, responsibility is not synonymous with fault. A developer may have done all that could reasonably be expected of it to build a safe building, but will still be considered responsible for the relevant defects caused by others. And the authority for that is paragraph 31 of the tribunal's decision in this case, which is at page 156 of the core bundle. So to obtain your RCO, no need to prove fault. And I should add, at no stage has Triathlon sought to establish that either SVDP or Get Living was at fault in any sense of the word. And this idea of sections 123 and 124 being what I call a practical and pragmatic set of provisions, you also get a flavour of that from the authorities, where the provisions have been elsewhere described as outcomes focused.
Responsible for, and perhaps in paragraph 2 of Schedule 8, is a party which caused the building to be erected.
Yes, but that's as far as responsibility goes. Not, for example, having to prove a breach of duty. I won't take you to the authorities. I'm conscious I want to cover a lot of territory, but again, for your note, outcomes focused comes from a decision of the First Tier Tribunal in a case called Waite and Kedai at paragraph 77, and that's in the core authorities bundle, tab 9, page 173. And then in the Vista Tower remediation order case, at core authorities, tab 12, page 330, paragraph 122, we see the First Tier Tribunal stating that it considered its jurisdiction should be more practically focused on ensuring the defects are remedied in a responsible fashion. I should say both are remediation order cases rather than RCO cases, but in my submission it's the same. There's no distinction to be made there. Indeed, the FTT in this case adopted Waite and Kedai at paragraph 98 of the judgment. And just building on that point about the section 124 being a no-fault jurisdiction, you say, well, where is fault dealt with? That's also dealt with in Part 5 of the Building Safety Act. Part 5 being the part where the leaseholder protection provisions appear. But it deals with it separately. And I'll come back to those provisions to look at them when we come on to ground 2. But if I could just, again, for your note, how's it done it? 1, the Act extended the limitation period for Defective Premises Act claims to 30 years. And it did that retrospectively.
135.
Section 135, yes. Page 51 of the core authorities. And in this connection, you'll no doubt be aware that the duty under the Defective Premises Act applies to developers as well as to contractors and consultants. And that's Section 1.4 of the Defective Premises Act that you'll see at tab 2 of the core authorities bundle, page 4. Then what Part 5 did at Section 130, it introduced building liability orders. They are orders which make associates responsible for breaches of duty, among other things, under the Defective Premises Act.
Is that discretionary or is that automatic?
Just and equitable. So that's page 42 of the authorities bundle. And then what?
The jurisdiction vested in the High Court.
In the High Court.
FTT.
Yes. And then what else it's done is it's introduced a retrospective liability for cladding product manufacturers at Section 149 of the Building Safety Act. And you see that in at pages 57 to 59 of the authorities bundle. So I think when the appeal by Mr. Allison was opened in Adriatic Lands, he talked about the purposes of Part 5, and he mentioned making those responsible pay as one of the 4 purposes he identified. In my submission, you see that in those provisions I've just mentioned to you, Section 135, 130 and 149. So now let me address you, if I may, on the just and equitable requirement of Section 124. In terms of the approach that a tribunal should adopt when deciding whether or not it is just and equitable to make an RCO, we do not challenge the FTT's findings at paragraphs 237 and 244 of the judgment. You have to have regard to the purpose of the provision and all relevant factors. And of course, you have to, picking up on that, you have to distinguish between the relevant and the irrelevant. The Section 124 does not require any specific factors to be taken into account. You see in other contexts where you're specifically directed to certain matters, for example, under the CPR. But this isn't that situation. It's completely open. But I really must emphasise the need to have regard to the purpose of the provision. And in that connection, can I ask you, hopefully still in the core authorities bundle, behind what I believe is now tab 15, the updated section on Benyon, at page 428, please. So this is section 27.6 of Benyon, and you see the principle stated at the top in the first 3 lines. And then if I could just ask you to, if I could just emphasise the paragraph that starts probably in line with the second pin of your file, even in cases where...
Sorry, on the same page?
Yes, on the same. Even in cases where some degree of interference. Legislations to be construed as interfering with interference of a person's proprietary rights no more than the statutory language and purpose require. So we submit...
So you accept that it's not just statutory language, but it's also a purpose.
Yes. And so we submit, when applying the just and equitable requirement, it's necessary to strike a fair balance between the interests of the applicant, the interests of the respondent, and the purpose of the statutory provision. Now, you will also have observed that once all the jurisdictional requirements for an RCO have been met, such as you've got a relevant building with relevant defects, the just and equitable requirement is all that remains to be satisfied before the tribunal may make an RCO. That, in my submission, is an important point. It demonstrates that it's not enough to satisfy all the jurisdictional requirements. And it also demonstrates that Parliament must have envisaged that there would be circumstances where it's not appropriate to make an RCO, even where all the jurisdictional requirements have been satisfied. And so I submit that a useful cross-check when reviewing the judgment below and your own judgment is to ask yourself this question: if what is said is right, when will it not be just and equitable to make an RCO against a developer?
Could you say that again, please?
If what is said is right, when will it not be just and equitable to make an RCO against a developer? And I say that because if, applying the reasoning of the tribunal or the reasoning in your own judgment, you cannot think when it will not be just and equitable.
So you're looking at the effectiveness of the reasoning, its implications for other cases yet to be decided.
Absolutely.
Yeah, but there's a fundamental principle here. When we look at judgments, for example, arrived at by the FTT, that's a judgment reached by that tribunal on the facts of that case.
Yes.
Another tribunal presented exactly with the same evidence might come to a different view.
It might do, and I am about to come on to how you review the decision and the principles that attach
That's
to
what
that.
I'm touching on, yeah.
And of course, I need to address you on that. But the starting point is that we say that this judgment does contain statements of principle that do need to be tested in this way. And just picking up on that, if I could just give you a flavour of what's going on at the coalface in relation to applications before the FTT under sections 123 and 124. There is not a single reported case yet where the FTT has declined to make an RCO in relation to a particular building. And in the related field of remediation orders under section 123, there is not yet a single reported case where the FTT has declined to make a remediation order. Some, but not all of the cases are in the authorities bundle. My junior has carried out an analysis of all the cases reported up to the end of February of this year. There have been 3 RCO cases, including this one, and 12 remediation order cases. In each, an RCO or RO has been made. And I should also advertise that the FTT is generally acting promptly. Hearings are coming on and decisions are being made within months, not years. So we are not in a situation where you sometimes see with new legislation where the higher courts need to set the right tone. The FTT has done that already and is doing that. It's moving at speed and making the orders. We, in my submission, are actually in a situation where a steer is required from the higher court as to when it will not be just and equitable to make an order. Now I come back to the point that Lord Justice Holgate just raised. I fully accept that the role of this court on appeal is to conduct a review rather than a rehearing, and that this court will not interfere with the decision of the lower court if it merely forms the view that it would or might have made a different order. I don't think you need me to take you to the authorities on that, but if you want a reference for present purposes, you have Carroll and the Chief Constable in Volume 2 of the Authorities Bundle, tab 15, at page 332, and it's sub-paragraph 13 to paragraph 42 in the judgment. For the reasons which I will develop when I address you on each of the various sub-grounds, you'll see I had 1.1 to 1.10, we submit that the FTT made errors of principle and fell into error in the factors that it did and did not take into account, and in the weight that it did or did not apply to particular factors.
Is that latter part something that is justiciable in this court? It's familiar to say the exercise of discretion is flawed if the lower decision-making body has failed to take relevant factors into account or taken irrelevant factors into account.
Yes.
But I'm not aware that it's a ground of appeal that we think different weight should have been given to factors.
Well, so I'll let you.
There is also a sort of catch-all, which is it's outside the reasonable ambit within which disagreement is possible, or such a decision as no reasonable tribunal could have reached,
yes,
and so on. But that's a sort of global thing. But simply saying, here's factors 1 to 10, they did take them into account, but they gave very little weight to factors 4 and 5, and they should have given more weight.
Yes.
I'm not aware there's authority that says we can embark on that exercise.
My lord, yes. But what you see, and we'll come on to it, is where they don't place any weight on certain grounds where we say weight should have been placed.
Yes, but that if you place no weight on a ground, that's not treating it as irrelevant. It's simply ascribing no weight to the factor. That's a distinction drawn by Lord Hoffman in a case called Tesco. You're not saying that where they've... Are you submitting that where they attribute no weight to a factor, they're treating it as legally irrelevant?
In effect, yes, they are.
Well, I think you will need to look at Lord Hoffman in Tesco.
My lord,
I think it's 1995.
My lord, I'll do that, and if I may, I'll address you on that in reply, because it's not a case I'm aware of or in the authorities bundle, but I will address you on that.
Because otherwise, following on from my lord, if a tribunal reaches a decision on weight, it can only be challenged effectively on rationality grounds.
Yes.
And would it be fair to say, in that context, we're here dealing with a decision by a specialist tribunal?
We are dealing with a decision of a specialist tribunal, but one thing I would say is that this is not a decision by a specialist tribunal having been applying a statute for a number of years and very familiar with it, day in, day out. You're almost in the same position as this specialist tribunal.
It's a specialist but inexperienced.
Specialist but inexperienced, yes.
But it does have, I mean, not to be facetious, it does have necessarily quite a lot of experience, not of this Act, which has not been enforced for very long, but of the relationships between landlords and tenants in all sorts of other areas. And so it is familiar with the general topic, and that's why Parliament's entrusted it to this particular chamber of the FTT.
Well, I think there's another reason, if I may say so, why it's been entrusted to this chamber, because it's got a narrow focus, in the sense that the High Court has a very broad jurisdiction and can hear cases by all parties. The FTT has a much narrower focus, typically, not exclusively, but typically landlord and tenant. And here, the jurisdiction is limited to landlords, tenants, and developers, essentially.
And associates.
Sorry?
And associates.
And associates, yes, of course. Of course. And so, it's got a limited purview in terms of the people that appear before it. But as a result of that, you can't, as you would in the High Court, for example, if you're a developer, bring in your contractor, your design and build contractor, or you can't bring in your cladding product manufacturer, or your architect, or anyone else. And the effect of that, of course, is that your decisions can come on much quicker. Whereas your traditional High Court litigation, once you've worked your way through the process of claims and Part 20 claims and hearing all the parties and so on, it means in practice your decisions are coming later and at greater cost.
I mean, to be fair, the FTT probably doesn't have experience beyond L&T dealing with developer relationships and development agreement relationships.
Exactly.
Which is presumably why the President of the Upper Tribunal and the Deputy President sat on this case.
The reason why the
Because
President...
in the Upper Tribunal you do have that experience.
Yes, but the reason why the President and the Deputy... I can't speak for them, but the context was this case properly was issued in the First Tier Tribunal. There was a directions hearing where it was suggested, because of the nature of the case in terms of volume and importance and significance, it should be transferred up to the Upper Tribunal, so that if there was to be an appeal, it could come to the Court of Appeal quicker, as you see from the judgment, the references I gave you. And so, in my understanding and in my submission, that's the reason why it went to the Upper Tribunal. And of course, once you're in the Upper Tribunal and the nature of the case, that's why the President and Deputy President sat, rather than because there was a requirement for broader expertise as such. That's certainly not why it was put, why the President and Deputy President should sit. So, in terms of the facts, I'm not going to address you on the facts of the case at this stage. I think you've got them from the judgment and the skeletons. I will, of course, pick up on them as I work through the different sub-grounds. You should also have seen an update note that was provided by EVML overnight. I'm not sure the extent to which it's relevant for your purposes, but sometimes the court likes to know what's been going on since. You've got that information. But as you can see, the tribunal's finding was demonstrably right. The orders were not required to enable the works to be carried out. The principal reference for that is paragraph 215 of the judgment at page 191. To be more precise, they said that there is no good reason to believe that the remediation works will founder for lack of money whatever is decided. And as I say, that's been borne out. So I now come to the sub-grounds that I rely upon.
And just as a debt clearing exercise, we don't need the legislation now. Do we need the legislation?
Yeah, let's do some tidying, I'm sorry. We can probably put the core authorities bundle away. And you can probably, but forgive me if I'm wrong, put the supplemental appeal bundle away. But I will be asking you to look at the judgment at this point.
Yes. Right.
And can I ask you please to go to the judgment at tab 11 at page 200. And can I ask you to read, please, paragraphs 264 and 265? So just to put you in the context of the judgment, the tribunal up to this point has gone through the facts and the jurisdictional issues, and it's identified various facts they say not to be of import, if I can put it in that way. And then at 264, they now start identifying the issues that they do consider to be of significance.
And so you'd like us to look at 264 and 265?
Yes, please. And so you see at 265, the first factor identified is the fact that SVDP was the developer of the blocks. And then as you turn over to the bottom of the next page, you see the question they pose at paragraph 269, which is if the funding of the major works is subject to only a small shadow of doubt, and if the defects will be properly remedied, why not leave it to the Building Safety Fund? Why make an order? And that's what we've called the public purse point. And that's where, and then you come on at paragraph 270, where the FTT go into their reasons addressing the public purse point, but starting, perhaps to my eternal shame, by saying that I couldn't identify a clear and convincing answer to that question. And that's a point I'll address when I come to ground 1.4. But could I just ask you to note, while you look at paragraph 270, 3 lines from the end of the paragraph, they refer to the best part of £20 million remaining in Get Living's bank account. Not SBDP, Get Living's bank account. And then if you could go to, just for this ground, 1.1, if you could go to paragraph 277 and 278, you'll see 277 is where they say again that I've failed to come up with a clear and convincing reason, but again referring to the money being in Get Living's bank account. And then you see 278 where they start their reasoning further. And that's a paragraph that we'll have to look at in a number of times. So can I ask you just to read it now and
yes,
digest it, please? So there are a number of points within that there's a specific issue relating to the LPI regulations, which I'll address when I come on to ground 1.2. You see there the point about the public purse acting as the underwriter of the risk of failure and being a matter of last resort. That's something I'll address at ground 1.4. But at this point, I address a more general point arising out of the fact that SVDP was the developer of the blocks and the significance which attaches to that. Because we say that the tribunal effectively created a presumption that an RCO should always be made against a developer with means. And the reason I say that is because we've already seen from paragraph 265 that the tribunal considered the fact that SVDP was the developer was important in any event. It was their first point. Now, of course, we accept that the fact that the respondent was a developer will be relevant to the exercise of the just and equitable discretion. But it can't be determinative in my submission, because otherwise there'll be no point in having the just and equitable requirement.
Well, they do say a developer who's well able to pay.
Yes.
And which is this case, because if you make the order against Get Living as well, then Get Living has the funds. One might conceivably have a case where someone was for development, but it would push them into insolvency in a way which might have all sorts of unattractive consequences.
Yes.
So just being a developer is not enough by itself.
Yes.
Why is that not a sufficient explanation of giving a discretion, making it just and equitable? And the tribunal is required to take into account the practical consequences of making the order.
Yes, but that's the order against the developer as opposed to the associate. And I'll come on to that. But I would ask slightly rhetorically, why would you even be suing the developer if they didn't have means? So the whole point is you're looking to get to someone with means under the provision. And if you're going after the developer, that's one thing. If you're going after an associate of the developer, that we say is something different and needs its own consideration.
Are you not entitled to look at the two together?
In some contexts you can, and it would be appropriate to do so. For example, if I was and you see the standard example in the explanatory notes, if I was a large development company and I set up Selby Developments Fetter Lane, and I did a development on Fetter Lane, and that was my subsidiary, and I built out a development and allowed Selby Developments Fetter Lane to go into nothing, and then took all the profits, then of course you can easily equate the parent company with the subsidiary as the developer. I'll say it now. We say that Get Living is not in that category because Get Living had no role in the development of this development. Get Living never set up SVDP.
Can I start a bit earlier, which is, do you accept the second sentence of 265? The policy of the Act is that primary responsibility should fall on the original developer, and others may pass on the costs. Do you accept that's part of the policy of the Act?
I say I accept it in this context, and this context is if you're looking in the narrow purview of responsibility between tenant, landlord, and developer. In that context, as between those three, when you hear the phrase hierarchy or cascade,
Yes.
Developer sits at the top.
In that case, what is wrong with them, with the FTT starting off with that point? They've identified, which is not disputed, that SVDP was the developer.
Yes.
If it's true, I mean, my understanding of the Policy Act is that leaseholders get protections,
Yes.
as long as it's their own home and so on and so forth. That means the costs have to be borne somewhere, and if the leaseholder's not going to pay it through the service charge, it pushes the costs up to the landlord.
Yes.
But that's not necessarily the end of it, because the landlord may be equally innocent as the leaseholder, be a subsequent landlord. What 124 does is enable the landlord, in appropriate cases, to push the costs up to the developer.
Yes.
And if that's hierarchy or cascade or waterfall is part of the policy of the Act, then it does seem an appropriate place to start.
Yes. In that sense, yes, I agree with you.
Right. So it's not wrong for them to give weight to that fact.
No, and I'm not saying it's where it's the next bit. It's in paragraph 278, because what they said is it's difficult to see how it could ever be just and equitable for a party falling within the terms of section 1243 and well able to fund the work to be able to claim that the work should instead be funded by the public purse. And it's that word ever. We say,
Or difficult. Are you saying that's determinative?
difficult to see how ever. We say, when you actually analyse that and read it in the context of paragraph 265, that in itself is creating this effective presumption.
Yes, I just want to be clear about the presumption you're talking about. You started off by talking about presumption. Is it one that's capable of being rebutted if they did have a presumption, or are you saying that they treated it as irrebuttable and this factor was therefore determinative? Because they're not the same.
Well, reading it in this way, difficulty, however, they leave a slight margin to rebut it, but very little scope when you think about it.
And would it be fair to say that in any event, the sentence is looking at, for want of a better word, a contest between the developer and the public fund?
Well,
It's not looking at the other parties as well.
well, yes and no, because what it actually says is anyone falling within terms of section 1243. So that isn't just limited to developers, but it also includes landlords. A landlord, he was a landlord at 14th of February 22, and associates. So
can I just be clear? Insofar as 265 might suggest that there's a presumption in favour of imposing liability on developers as compared with landlords or whatever, that you don't quarrel with.
as a starter for 10, which is yes, I don't quarrel with that. It's when you read 265 with 278.
So the particular complaint is the presumption that you have to land someone eligible for an order under 124 with a bill in preference to the public purse.
Yes.
But when you corrected me just then, by referring to section 124, subsection 3, it's no longer a presumption tied to the developer.
No.
It's broader.
Broader.
But all it's doing is comparing the position of the public purse with everybody who potentially falls within section 1243.
Well, yes, you can read it in that way.
It's not the hierarchy starting with the developer anymore. It's broader than that. I mean, what's questionable about comparing the position of the public purse with everybody who potentially falls to be on the receiving end of an RCO?
Well, I'll come back to that in the context of this case when I come to ground 1.4, if I may. But as a general proposition, it's a different kettle of fish, if I can put it that way. But my real point is on the facts of this case. They do leave very margin for manoeuvre.
But the point in 278, as I understand it, is not so much should it end up with the developer. That's the point in 265, as between landlords, subsequent landlords,
Yes.
and the original developer. The point in 278 is, why should the public pay if there are people who can pay, who own interests or were responsible for the development in the first place? In other words, the people with interests in the property, historical, present. The point they're making here is, why should the public pay, the taxpayer,
Yes.
as opposed to those who are interested in the property? Is there anything wrong with that as a general proposition? In other words, that
Yes.
the public purse is a last resort. No,
Yes.
that doesn't always mean that if you can find someone in section 124.3, you make an order, because obviously there are other factors. But simply saying you can't make an RCO against against the public. They're not there as a target. They're there to step in to fund works if nobody else can. But they are there as a last resort, and that's, I mean, this may not be your ground one, it may be one of your other grounds, but that's really the point they're making, isn't it?
Understood in that way, yes, that is an acceptable proposition, yes.
But are they saying any more than that? If they're saying, it's difficult to see how, if you've got someone who can pay who's within Section 124, one of the people connected with the building, if I can put it like that, they should pay rather than the taxpayer.
Let me try. Let me try my coat on ground 1.4, because where I get to is that, in essence, the public purse in this case is in the same category as the developer or an associate of the developer, because this was a development by the Olympic Delivery Authority.
But that's a very specific point on this particular this particular development, and we'll get to it. But they have answers to that. But that's not a general point.
No,
I thought you were criticising 278 as being setting up as sort of a general point, as between the taxpayer and those connected to the building. It's those connected to the building who prima facie should pay rather than the taxpayer.
no. At a general level, I can't challenge that. No. Can I come on to ground 1.2, the LPI regulations? We've already seen the relevant parts of the judgment at 278 and paragraph 265 about the LPI regulations. And it might be we may be able to take this quite shortly, given the exchanges we've already had. But let me try and work through it just so you've got it in the framework of 1.2. The LPI regulations create what's referred to as the cascade or hierarchy of liability that we talked about, with the responsible landlord, i.e. the developer landlord, or a landlord that's associated with the developer, standing at the top of the list of those liable under the regulations to meet the costs of remediation under Regulation 3. Then it's landlords who meet what's called the contribution condition, and that's if you have a net worth which exceeds the number of buildings you own multiplied by £2 million. That's Regulation 4 of the regulations. And then at the bottom of the LPI regulation cascade, you have other landlords where tenants are not otherwise liable to pay for relevant work.
Can you say that last one again? Sorry.
Regulation 5, other landlords where tenants are not otherwise liable to pay for relevant work. The LPI regulations appear in the Court Authorities bundle at tab 6. And for present purposes, I'll just go to page 92, Regulation 3, which is the developer landlord provision. And just looking at 3.1, what we see clearly from that is what these regulations do is regulate the position between different landlords in the chain of title. So if one landlord pays or becomes liable to pay for the remediation works, they can then claim the cost from the developer landlord by issuing the relevant notice, if you're in Regulation 3 territory. And so what they're demonstrating is, as between landlords, the developer landlord should be the landlord that ultimately foots the bill for the remediation.
Is it right to say, looking at 3.1 with its cross-reference to paragraph 2 of Schedule 8, that this distribution as between landlords only applies in that situation where the costs can't be put into a service charge by virtue of paragraph 2?
Yes.
Remind me what paragraph 2
Yes.
does?
Paragraph 2 of Schedule 8 is the provision, I'll just give you a reference so you've got it. Schedule 8, paragraph 2 is at page 68 of the bundle.
These are the ones you're responsible for.
Yes, so
You're the
that's
responsible landlord.
yeah. No service charge is payable where the landlord is a responsible landlord, i.e. a developer or their associate.
So what it does is that you may have a landlord. First of all, the service charge can't be obtained from the leaseholders because of paragraph 2, because there is a responsible landlord. But that may prevent a non-responsible landlord from recovering under a service charge provision, and then they can use this cascade arrangement.
Yes.
Yeah.
What we say about these regulations is they don't go any further beyond regulating the position between landlords within the chain of title.
But it's an indicator, isn't it? As long as you don't treat it as being determinative, it's a factor, isn't it?
Well,
Not irrelevant.
it's not irrelevant, but what does it tell you beyond what we know already about the developer's position in the cascade? We say nothing because, for example, Get Living is not a landlord.
Is Get Living associated with a person responsible for a relevant defect?
Well, it's associated with the freeholder.
Which is the 2 trustees.
The 2 trustees, yeah.
And the 2 trustees are associated with the developer, which is SVDP. So, this is a case within paragraph 2 of Schedule 8.
Yes.
Because the relevant landlord, the freeholder, the 2 trustees, they're associated with the person responsible for a relevant defect, which is SVDP, because SVDP developed it in the first place.
Yes.
So it's a Schedule 8, paragraph 2K.
Yes.
That means Triathlon, which is a landlord, can use Regulation 3 to push the costs onto the freeholder, the 2 trustees, doesn't it?
If, and this is the big if, it has, paid or become liable to pay the cost of a relevant measure. So that's Regulation 3.1.
But if it doesn't get an RCO, if it hadn't applied for an RCO, it would be liable to pay, wouldn't it?
Well,
Triathlon would be liable to pay EVML.
Well, no. Well, Triathlon has never paid for the remedial costs.
I understand that.
And it's never become liable to pay for the remediation costs because the remediation contract was entered into between EVML, the management company, and the remedial works contractor, a company called Erigal.
But is EVML not entitled under its leases to pass on the cost of triathlon? That's the whole problem.
Well, but for Schedule 8, paragraph 2. And of course,
I see.
Yeah, so, and it's accepted in this case and was accepted before the hearing that Triathlon was not liable for the cost of the remedial work.
But solely by virtue of paragraph
By virtue of Schedule 8, paragraph 2. So that's my point for this case. Triathlon cannot avail itself of the regulations.
Right.
And so resort to the regulations tells you nothing about what triathlons
Could EVML use the regulations? EVML it has paid. Is
or become
paying,
liable to pay.
Or become liable to pay. Is paying the costs of the measures. EVML is
A landlord.
a landlord, and this is a paragraph 2K. So could EVML use the regulations, push the costs onto the freeholder?
We say no on this case because it would be in breach of the funding agreement, the grant funding agreement, which is a point I'll come on to when we come to ground 1.7 for your note. You see how they all interlink.
But for the grant funding agreement, does it come within the regulation? Does EVML
Yes.
come within regulation 3 of the regulations?
Oh, I'm sorry, my junior telling me no. Yeah, so there is a substantive point. You've seen from the update note that Regulation 3 notices have been issued.
Right.
By EVML,
By the EVML.
and they are the subject of appeal. And one of the grounds of appeal covers whether EVML can make can issue such a notice.
It's a moot point, is it?
It's a moot point. I don't know if you want to hear from my junior about what the point is, or
let's keep going for
Yes.
the moment because you haven't got so much time.
yes. My concern about the Regulation 3 notices is there was no issue before the tribunal about the right or ability or inability to make a Reg 3 application, and so it's not before this court either.
But just to get my thinking on this clear, what are you saying about the LPI factor? Are you saying it's legally irrelevant
It's irrelevant because it
to the
tells.
position of Triathlon as an applicant?
Yes.
Well, I follow what you're saying, but if Triathlon had been able to rely upon the LPI regulations, which they're not,
Yes.
say, then of course there would be no need for a Section 124 application by then.
Yes.
Yes, but given that they're not, for the sake of argument, and they do make an application, why can't the tribunal look at the LPI regulations for a policy purpose?
Well, for simply a policy purpose, there's no objection. But if you're deriving any more than that, there is an objection because one, as we've discussed, Triathlon doesn't have a right under the regulations. But two, Get Living doesn't have a liability under the regulation.
So what is it at the end of the day that the tribunal did with the LPI regulations which was legally wrong?
Well, what they came to was, I think it's at the end of 278. They took it in. They took into account that they felt the EVML had an unanswerable claim under the regulations. Sorry, 265.
Because 278 mentions the LPI regulations in the context of contrast with the public fund.
Yes, sorry,
So
forgive me.
that's not the problem.
No,
Right?
it's
265.
yes. So they and they said that to be relevant, and for the reasons I've explained, it's not relevant because the regulations don't tell you what should happen where the parties to the RCO application are not parties who are subject to the regulations. And also, as I've said, liability under the regulations was not an issue before the tribunal. And so we do not accept that there is an unanswerable claim, as you've already heard.
But insofar as they rely upon it, they call it a policy, and the preceding sentence goes back to primary responsibility lying on the developer point.
Yes.
Thank you.
Because
It's the word unanswerable, is it?
yes,
That you don't. But you say there wasn't any argument about it.
there wasn't any argument about it, and as I've said already, the fact, even if they're right that there's an unanswerable claim, it's between two different parties.
But they only say it's an unanswerable claim to recovery against SVDP's trustees. No.
Yes,
They're not saying there's an unanswerable claim against Get Living.
well, except
This is part of saying the policy is that the developer is primarily responsible.
well, they do go further. If you look at the end of 265, they say the availability of an alternative and unanswerable route to recovery against the trustees is a strong indicator that it's likely to be just and equitable for SVDP to be ordered to pay. So
Is that wrong? I mean, if they're right about it being unanswerable, and I know you say they're wrong about it, but if it were the case there was an unanswerable claim against the trustees hold a freehold and trust for them, is it wrong to say that's a strong indicator that it's likely to be just and equitable?
if there's an unanswerable claim between two parties, and the RCO is between those two same parties, then
You see,
that has some force, but that's not the situation.
because of a difference between SVDP and its trustees?
Well, because of the difference between not because of SV, because we've got different parties, Get Living.
But this is not about making an order against Get Living. This paragraph is about it being just and equitable to make an order against SVDP.
But it does come back when the LPI regulations are referred to at 278. The LPI regulations come back. We looked at that.
I mean, they're used as a factor leading to the conclusion that the public purse is the last resort.
Yes.
I mean, if they're right that the public purse is the last resort, does it matter whether they took into account the LPI regulations in arriving at that conclusion?
If that's all they've done, then there can be no quibble.
Yeah.
So, can I come to ground 1.3, motive and identity of the applicant?
Yes.
Paragraph 246 of the judgment, page 196. That's where the tribunal stated they do not think it's relevant to the exercise of their discretion to draw conclusions about Triathlon's motivation in bringing these applications. And then at 271, page 202, that's where the FTT relied on that finding and said it's not usually of much significance in rejecting one of my grounds of defence to the public purse argument. So they're the two relevant paragraphs. Let me deal with motive first, then identity. In my submission, the rejection of motive as being relevant cannot be right for 4 reasons. First, let's not forget that the applicant is referred to in section 124 as the interested person. In other words, section 124 expects that the applicant has an interest in the order that is being applied for.
I mean, to be fair, that's a defined term, isn't it?
It is a defined term.
I mean, the word interested has featured, but even so, actually you have to look beyond the definition.
And the definition is various classes of people, and you see that 1, 2, 4, 5 at the bottom of page 89.
And an interested person can include, for example, the Secretary of State or the regulator.
Exactly.
And they don't have interests in the property.
No, so it's not about having a legal or equitable interest. Although that does give you the right to apply at subparagraph E over the page.
Yep.
It's looking at a broader interest. So you see, for example, it's the Fire and Rescue Authority, whose jurisdiction within which the building sits.
By interest, it sounds as if it means standing. It's defining who wouldn't be a busybody.
Quite. But even as you say...
But would you need to look at the motive of the Secretary of State, for example, or the regulator?
You don't... Well, in many respects, you could say the motive is assumed. Secretary of State could well appear and say, I want to make sure these buildings are fixed in accordance with legislation. And do you need to go any further? Probably not. But in other cases, motive is important because and this is really my second reason, which is when exercising a discretionary power, such as just and equitable, it's necessary to have regard to the purpose of the statutory provision and balance that with the interests of the parties to the application. So when you're doing that balance, you've got to ask the question, why? And you've got to ask whether that motive aligns with the purpose of the statutory provision. My third point is that orders are not made in a vacuum. In many senses, it's a similar point. When making an order, it's necessary to consider whether the order is necessary and whether the order will achieve the purposes for which it's being applied for. How can you make an order that is just and equitable without knowing the reason why you are making it? And then my fourth point is very similar to my third. To avoid violating A1P1 of the ECHR, there has to be a reasonable relationship of proportionality between the means employed and the aim sought to be realised by any measure which interferes with a person's peaceful enjoyment of their possessions. In other words, you can't assess the proportionality of the order without also identifying the aim sought to be achieved by it. Now, we know the statutory purposes of section 124. One purpose is to ensure that relevant defects are rectified without delay. But that was being achieved in this case and has been achieved in this case, as the FTT found. Another purpose is to ensure that leaseholders are not left to foot the bill or exposed to high service charge demands. But there was no suggestion of that happening in this case. We've already discussed, for example, it was accepted that Schedule 8, Paragraph 2 was engaged. All parties made clear that the safety of residents was paramount, but that aim, as we've seen, was being achieved without any order because the works were funded and underway. At paragraph 246 of the judgment, the tribunal said that there was no doubt, it was no doubt part of Triathlon's thinking that it wanted to ensure that it would not be called upon to meet any of the cost of the remediation itself. That's at page 196. But even if that were Triathlon's motive, which I must stress Triathlon still doesn't state, there was no need to make an RCO to achieve that aim, because it had already been accepted that Triathlon couldn't be liable for the remediation works. because of the provisions of Schedule 8, Paragraph 2. And of course, Triathlon had not paid anything towards the remediation costs.
So just catching up with you, Triathlon couldn't be liable by way of a service charge, but would that rule out the possibility of someone making an application for a Section 124 order against them?
It would not rule out an application, correct, yes. But there was no application.
No,
and certainly no order.
No.
And just maybe it's a nitpicky point, my lord, but of course you can't be liable. Triathlon couldn't be liable without an order.
Of course, yes.
Yes.
But an application could be made at some other time.
Yes. There was no suggestion also that Triathlon was pursuing this application to enable EVML to discharge its obligations under the grant funding agreement. And that couldn't have even been credible had it been said, because the applications for RCOs were made about 2 months before the application for funding had been approved, and about 6 months before the grant funding agreement was concluded. And of course, as we've seen, the application only ever related to Triathlon's share of the remedial costs rather than the whole remedial costs, which is what the grant funding agreement covers. So we say it's highly material that Triathlon could not identify any personal motive that justified the making of the order. And the tribunal erred in failing to draw conclusions about Triathlon's motivation in bringing these applications. Now, it's an interrelated point, but let me come on to the identity of the applicant. I submit
Have you finished with your criticisms of 246?
Well, I think 246 picks up identity as well.
Okay, sorry.
246.
I mean, does
Principally
the
motivation.
tribunal actually say that they're treating motivation as irrelevant?
Well, they must do, because they said they don't need to make any findings about why it seeks the order.
Well, the obvious question is, what were your clients saying that their motivation was? And that's dealt with by the tribunal in the middle of 246. The real motivation was to ensure that Triathlon was not called upon to meet any of the cost of remediation itself.
Yes.
Not suggested this was improper, nor could it have been. There's no criticism of that. No doubt it's part of their thinking. And then the tribunal goes on to say, in the absence of any malice, etc., or improper motive, this is not something which is going to help us. Is there anything wrong in that?
Well, my lord, yes, because when it comes to it, I think the reference was paragraph 2. Let me go back, sorry. 271 of the judgment. Because it... Yes, at 271, 5 lines down, we have already said that we do not think the motivation of an applicant will usually be of much significance, nor do we think it matters much who the applicant is. And that's where they're rejecting the public purse argument. And we say that they're wrong in that situation, because what the tribunal should have found was that there was no motivation to reimburse the public purse. Why are you making the order?
So can I just understand? They should have found there was no motivation on the part of the applicant to reimburse the public purse.
Yes. And
what's the legal effect? Say you're right.
And also, forgive me, I think I'm interrupting you.
No, you're not.
But also no relevant motivation that justified the making of an order for the reasons that I've explained. Sorry,
say you're right. Would that then have the legal consequence that the tribunal could not take into account the effect of whether an order is made or not on the public purse?
Well,
just because of the absence of that as a motivating factor on the part of the applicant.
Well, it can take that into account, when they said I failed to provide any clear and convincing reason, and one of my reasons was that there's no intention behind the application to reimburse the public purse. In my submission, that is an important factor to take into account, because if it's the tribunal acting off its own initiative, essentially, rather than because of the applicant, then that is important to throw into the balance in my submission.
So just to be clear, on your hypothesis, I mean, Triathlon made an application. So
Yes.
why did they make the application?
My lord, I genuinely will never know. I talked about how they said that the safety of residents was paramount and so on. But as I said, that can't logically justify the order or the application.
Well, again, going back to 246, the tribunal recalls your case that the real motivation was to ensure that Triathlon was not called upon to pay.
Yes.
And no one suggested that your case was misrecorded.
No. But if that was the motivation,
It wasn't the public purse motivation.
it wasn't a public part, and it didn't justify the making of the order because they weren't being called upon to pay.
Well, not at that point, but it might be something to a risk of being called upon to pay. We discussed the section 124 point.
But not when the works are funded and underway.
Yeah.
I could say there's a residual risk if you push me, but I'd put it no higher than that.
Yes.
Identity of applicant. But in my submission, the identity of the applicant must be relevant also. As a general proposition, if the identity of the respondent is relevant, we talked about in 1.1, developer, so must the identity of the applicant. But in any event, the identity of the applicant must be relevant. And let me illustrate it in two ways. The first is a major feature of the BSA is the intention to protect leaseholders. So if the applicant for an RCO was an individual leaseholder or a group of individual leaseholders, surely that would carry much weight. I think the tribunal would accept that, given what they said, again, just for your note, at paragraph 263 of the judgment, where they referred to the evidence of the individual leaseholders. But secondly, it must be relevant because we talked about the hierarchy under grounds 1.1 and 1.2. The FTT considered the hierarchy to be important. And if that's right, it must be necessary to consider where the applicant and respondent sit within the hierarchy. What if, for example, the facts of this case were reversed and it was the developer freeholder applying for an RCO against the landlord long leaseholder? Surely the identity of both applicant and respondent would be relevant. So I'm going to try and beat your lordships to it. The real question on those grounds is, so what? So what? Why does this matter? And we say that the tribunal ought to have taken into account what the tribunal ought to have taken into account, and it didn't do so, is this. The fact that Triathlon was a long leaseholder of a large number of the flats in the blocks, with no liability to pay for the remedial works, who was protected from having to pay for any remediation costs, with no apparent reason for applying for the RCOs, in circumstances where the remedial works were funded and underway. As I've tried to explain to you, this application by Triathlon could not be about any interest in the building or building safety.
And just to go off briefly to tangent, in the end, the order provides for the money to be paid to EVML.
Yes.
And Triathlon's application contemplates payment to EVML.
I can't remember if it originally did, but ultimately it did.
And EVML could have made the application.
EVML would have had standing as someone with a legal or equitable interest, yes.
And had it done so, you couldn't possibly have quarrelled with motive or identity.
It would have been very difficult for me to do that, yes.
Yeah.
But is part of the factual matrix the control issues that were going on in EVML until shortly before the hearing before the FTT?
Yes.
That might explain why Triathlon applied.
Well, as I say,
It's not difficult.
I can't speak for Triathlon or EVML, and the issues within the management of EVML do cut both ways, as we might come on to.
Yeah.
So then we come to ground 1.4, public person, the underwriter of the risk of failure points. And here I also address what's formerly called ground 1.10, very similar points. And they also feature in the same paragraph of the judgment which we saw. But let me start by addressing head-on the challenge that we've already looked at. What was said to be my failure to identify the clear and convincing reason why the public should carry on as the interim funder. And it might just be useful to have open paragraph 270 of the judgment at page 202 at this point. It's just worth focusing what they said. I found it difficult to identify a clear and convincing reason why it would be just and equitable to allow the best part of 20 million to remain in Get Living's bank account. And that's my first point. Because the question is the wrong question in my submission. The question should not be, why is it just and equitable for money to remain in Get Living's bank account? Rather, the question should be, why is it just and equitable for money to be paid out of Get Living's bank account? That's the order that was being applied for, in order for Get Living to make a payment. And that is an order which can be made without the need for it to be established that Get Living was in any way at fault. We say, if any person, whether they're a developer or a landlord or one of their associates, is to be ordered to pay substantial sums of money without the need to have to prove that they were at fault, there has to be a compelling reason for that. In other words, using the rubric of section 124, there needs to be a compelling reason why it's just and equitable for Get Living to be ordered to make the payment.
But again, the sentence doesn't stop there. Why should it remain in that account rather than being returned to it's the antithesis with public funding.
Yes, true, but still, it does, if I can put it this way, suggest that they're looking at it the wrong way. And they put it in the same way at 277. Second point follows on from my first, and it's really see my arguments on ground 1.3. their rejection of motive in the context of the public purse argument. Third point is the arguments I'm going to make on this ground 1.4 and 1.10. I'll address you on that more fully shortly, but the headlines are this at this point. Contrary to the Tribunal's finding at paragraph 278 of the judgment, BSF funding is not a matter of last resort, and the public purse is not the underwriter of the risk of failure. At this point, I should record that BSF funding and RCOs are both part of the wide set of legislative and non-legislative interventions aimed at addressing the building safety crisis. You've had plenty of that already. But so, when considering these RCO applications, it's necessary to consider how they relate to other relevant parts of the set of interventions. So, in the same way that the RCOs made by the Tribunal were crafted in such a way that they didn't impose any additional obligations upon EVML over and above those contained in the grant funding agreement, we say RCOs should not be made that impose any additional obligations on the appellants over and above those contained in the grant funding agreement. Rather, RCOs should only be made if there's evidence that the funding agreement is not being complied with, which doesn't apply here, or to the extent required to ensure that the funding agreement is complied with. Now, we've already seen how the funding agreement envisages a period of some 12 years for reimbursement. I would simply add that there is nothing in the Building Safety Act that says that public funding is a matter of last resort. Fourth point, it's a coat trailer. See what I say on grounds 1.6, 1.7 and 1.9. So they are all matters that are relevant to the rejection of the public purse argument. Fifth point, and this is an important point that you may not have necessarily appreciated, and it's this: the Building Safety Fund doesn't cover the cost of rectifying all relevant defects that may exist in a building. When I use the term relevant defects, I mean that using the language of the Building Safety Act. The Building Safety Fund only covers the cost of rectifying life safety fire risks associated with cladding. It doesn't cover the cost of rectifying, I'm going to give you an example rather than the whole list, internal fire safety defects which may be discovered. Perhaps if I can explain that for the Tribunal. You're well familiar with the concept of the stay put strategy, the idea that if there's a fire you can stay in your flat. The reason why that should work is your flat should be a self-contained box into which the fire can't penetrate. Internal safety defects arise where that self-contained box is undermined. So for example, your walls, there are large gaps between where your wall meets the ceiling, and so fire can spread from one flat to another. Those sort of defects are not covered by the Building Safety Fund.
Where do we find the limits of the Building Safety Fund's responsibility?
The precise limits, there is funding guidance that's published online.
Do we have that?
No, not in the funding.
It's not in the statute. The Building Safety Fund's not.
No,
it's not part of the statute. It's outside the statute.
It was created before the statute, but as you heard yesterday, it was part of the interventions.
Yes.
Sorry, yesterday or Monday.
But if we want to understand this submission, it only covers the costs of rectifying live safety fire risks from cladding defects.
Yes.
That's somewhere in some published material which we don't have. Is that?
Yes,
is that
it's the rules of the Building Safety Fund.
I mean, it may be best if at some stage we could be given at least a relevant part.
Yes, we probably don't want the whole thing, but the bit which
I'm sure
which
you
makes,
don't.
which makes good what you've just told us. I'm
Yeah.
not suggesting it's wrong, but it just so
Yeah, just in the context of making good, and it doesn't fully, but at least gives you a flavour. In the update note that you were prepared overnight, you would have seen at paragraph 4 on the second page.
I see. Outside the scope.
Yes.
Yes, I see.
So I can absolutely, I can give you more, but I can also assure you that's not a controversial proposition.
Yeah. You may also, hesitate to interrupt, get some from the grant funding agreement terms in this case. It's a standard form agreement, but you'll see the focus is very much on cladding.
Thank you.
That's supplemental bundle, section E, tab 3.
The other example I'll give you is you'll have seen that definition of relevant defect includes structural defects. I'm using that in a very high level sense.
Risk of collapse,
Risk of collapse. That's not covered by the Building Safety Fund either.
which is just fire related.
Just fire. So we say it's entirely appropriate that public funding should be part of the solution because there are other aspects of the buildings that will need repair in addition to those areas that are covered by the funding. The other element which the BSF doesn't cover is the cost of pursuing claims against third-party contractors and the like. So the applicant and the recipient of funding only gets funding in respect to the cost of remedial work. You then have to follow through your obligation under 5.4, but that's an obligation you have to comply with at your own cost.
But if you succeed, what you hand over is the net figure.
Yes. Sixth point relating to the public purse argument, and that's a point recorded at paragraph 274 of the judgment. I put it in this way below, which is this was a public project through which the public benefited, not least when it obtained all the sale proceeds arising out of the sale of SVDP in 2014. Just to give you a bit of flesh on the bones to that, with some paragraph references to the judgment. SVDP was originally in public ownership, having been set up and owned by the Olympic Delivery Authority in 2009 for the sole purpose of funding and developing East Village. That's paragraphs 130 and 140 of the judgment. When SVDP was sold by the Olympic Delivery Authority, the capital value of East Village went to the public in the form of the ODA, and that's paragraphs 131 and 141 of the judgment. And so coming back to the submission I made earlier in the context of ground 1.1, using the language of the Building Safety Act, the ODA was the developer or an associate of the developer. So, on the facts of this case, the taxpayer does appear in the hierarchy. And it appears in the same category as the developer. In other words, in my submission, this is a case where it's right for the public to share in the responsibility for the remediation of blocks by providing the forward funding for the remediation works. And let's not forget, as was accepted by Sir James yesterday, the government also bore some responsibility for the flawed regulatory system. You'll remember he referred to the Grenfell Tower inquiry and the findings in the report. And you may also have seen, depending on how much you've dipped into the supplemental bundle, that the government is positively relying on the existence of funding to encourage people to rectify buildings which contain unsafe cladding. Perhaps you might need to look at that. That's at the back of the supplemental appeal bundle, behind divided D for Delta 7 at page 170. It's a letter from the Secretary of State herself, dated the 1st of December 24, and you'll see from the second paragraph where she says government funding has been available since 2020 to support remediation. And then 3 paragraphs on the bottom, our partners Homes England and the Greater London Authority stand ready to support your application and help you to progress. And this is recorded by paragraph 200. Sorry, supplemental can go away once you've digested the letter.
It doesn't say who it goes to. Presumably goes to the owners of buildings? Or local authorities?
It was sent to anyone who's on the list of being responsible for repairing buildings. And I believe it was received by EVML for the purposes of this. How this gets into the bundle is it was received by EVML and they wanted it in the bundle.
There'd normally be a circulation list at the bottom of the letter.
Possibly.
Well, I suppose it might be rather a long list here.
Yes, that's. So, and just picking up on that, and it's recorded by paragraph 210 of the judgment, there was no evidence of any pressure from the fund's administrators for EVML to be more proactive in the pursuit of its claim against Galliford Try, nor of any relevant policy that the BSF may have adopted in relation to third-party claims. So we say in this connection, it would therefore be an undesirable message for the courts to say that any public funding received, when you're entitled to receive it, could well have to be paid back immediately, despite the terms of the grant funding agreement. Now, it's at this point I come back to the point I said I'd come back to, which is the underwriter of the risk of failure point. The idea that the public purse should not be the underwriter of the risk of failure. We say that's not so and need not be so in 2 alternative ways. First, the tribunal could have made no order, but with liberty to apply for an RCO in the future. For example, come back to court and say they're not, either Get Living is stopping EVML from pursuing the claim, or EVML is not pursuing the claim for any other reason, effectively, and so now's the time for the respondents to pay up. Or what the tribunal could have done to avoid the underwriting being done by the public was to make an RCO now that is actually aligned with the terms of the GFA, of the grant funding agreement, in the same way that it is for the purposes of EVML. And that's what we propose at paragraph 50.2 of our skeleton, where we propose that RCOs could be made on terms that require the respondents to pay for the remediation works following the conclusion of the Galliford trial litigation, whatever the outcome of that litigation. So if you win, you've got recoveries that you can then use to discharge the funding obligations. If you lose, then it's on the developer. And we say that is a more proportionate and appropriate response to the application on the facts of this case. And in either situation, the public purse is not the underwriter of the risk of failure. On the contrary, the underwriters of the risk of failure are the appellants, SVDP and Get Living.
Does that, if that were adopted, would it mean that the making of the RCO would simply be a question of timing?
Yes.
The ultimate incidence would be the same.
Yes.
It's either pay now or pay later.
Yeah.
So does that amount to accepting that there could be an RCO, but in different terms,
Yes.
as you've just described?
Yes. Believe it or not, I'm doing quite well on time.
Oh, good. Just if you're leaving the public funding point,
Yes.
You took us to paragraph 274, where your submission is recorded that the public did very well out of the sale of the property.
Yes.
I'm not sure I'm clear where that feeds into your submissions now, if indeed it does.
Well, the reason why it feeds into my submissions is when you look at the overriding intention, especially when you're thinking about associates, is the whole intention was to catch developers who build through SPVs. And so who was the developer in this case that built through an SPV? That was the public.
I mean, what we're concerned with is whether the First Tier Tribunal went wrong.
Yes.
Did they go wrong in this respect?
Yes, because they rejected that argument.
Where did they do that?
Sorry, we were. What was the paragraph we were talking about? It was
274.
274. Yeah.
I mean, they do say 276. None of these points seems to provide a good reason.
Yes. So they don't reject it as a factual proposition, but they reject it as a good reason.
Yes, I see.
Well, what do you understand good reason to mean? Say it's not factual. Why isn't it an exercise of judgment?
Well,
About
because
deciding how much weight to give to the point.
well, because when you talk about the cascade, they've ignored the fact that actually the public is in that cascade. They took the view that the public was not in the cascade. But actually, when you understand the facts, they are.
And it's not something they come back to later.
No. What they say. Yes, if you look at paragraph 278, third line, they say the taxpayer does not appear in section 124 or in this hierarchy, save insofar as a taxpayer-funded entity may constitute a body corporate or partnership within the terms of section 1243. So they state that proposition, but they don't actually say, well, in this case, the public, at least in a sense, does.
By the time the RCO was made, the Olympic Delivery Authority ceased to exist. Does that affect them?
And its liabilities were transferred to the Department for Culture, Media and Sport.
Yes, but would that allow you to obtain a 124 order against the department on the basis that it was an associate of the developer? Because one might think it was only the liabilities to which the ODA was subject at the time of its demise.
Well, there could be an argument as a matter of strict analysis of the statute, and probably the I think it's an executive order, but I may be wrong, transferring the liabilities from the ODA to the DCMS, whether that captures a liability under section 124. I see that. But when you're looking at what's just and equitable,
Yes,
you can go broader.
You don't need to rely on the technicalities.
Exactly.
And I quite see the point about technicalities or whatever, but just so I understand, did the ODA have any money at the point at which it ceased to exist? Liabilities, you say, went over. Were there assets that went over as well?
I cannot say.
No.
All I can say is the ODA did receive the sale proceeds of the development.
Yes, I see.
I suspect the Olympic Delivery Authority was a loss-making enterprise overall.
I'd hate to guess. Just because of time, I'm just going to record. I do make some challenge to paragraph 279 of the judgment, but I don't think I need to deal with that orally now. Can I just ask you to note against 279, see paragraphs 51 to 54 of my skeleton argument. Because then I can come on to ground 1.5. And this is the proposition that the tribunal found that it's not unfair for Triathlon to pursue a remediation contribution order rather than other claims. We say it's not unfair. Sorry, it's all the multiple negatives, forgive me. It was found by the tribunal that it's unfair for Triathlon to be required to pursue its other claims rather than allow it to pursue a claim for a remediation contribution order. We say that finding's wrong when in circumstances where the remedial works were funded and underway. Because as a broad headline, the purpose of section 124 is being achieved. Now, let me develop that if I may, please. In the context of ground 1.2, we've discussed the hierarchies within the Building Safety Act. An important point to have in mind in this context is that the hierarchies, it's something we've already touched upon, only look at the position between leaseholders, landlords, and developers. The hierarchies do not look at the broader picture, such as whether there are other parties who could be said to be more responsible for relevant defects, such as designers, contractors, and product manufacturers. So, for example, the Act says nothing about Galliford Try and its responsibility for the defects and how you factor that into the just and equitable balance. And I don't think I need to take you to the paragraph because I agree with it, but at paragraph 256 of the judgment, the tribunal found that the ability or inability of a respondent which is treated as responsible for the purpose of the act to pass on liability to some other party who may be responsible under the general law was not a matter to which much weight should be given. Fine, but please look also in that vein at paragraph 261, and that's at page 199.
Yes.
Now, we agree with the proposition that an RCO should provide a route to securing funding for remediation works without the applicant having to become involved in or to wait upon the outcome of other claims. But that's not the issue in this case. Because, and I'm sorry if I'm droning on, as the tribunal found, the remediation works are funded irrespective of the outcome of the RCO applications. So this is not a case where any of Triathlon, EVML or any other leaseholders are having to await the outcome of other claims before funding is secured. And in this case, where the remediation works are funded and Triathlon is not being required to pay for the works, and where there are other claims available to allow the funding to be recouped, we submit that the tribunal erred and the presence of other claims should be a material factor against the making of an RCO in this case. Let me develop that. The respondents are required under the RCOs to bear the whole cost of the remedial works. And before they make that payment, they are unable to obtain contributions from others, in particular contractors and consultants, because they, as we discussed, can't be parties to RCOs. They can only be pursued in the High Court. And that, we say, is not just and equitable when the statutory purpose of getting the buildings fixed is being achieved. Now, a point that will be said against me, no doubt, is that this is a risk that QDD, the subsidiary, assumed when it purchased SVDP, because it bought the company rather than the property. But as the FTT found at paragraph 163 of the judgment, those risks were to be mitigated by warranties from the consultants and contractors engaged on behalf of SVDP to carry out the development.
Which paragraph was that?
Sorry, paragraph 163, page 181. And the date of the purchase was 9th of August 2011. At that point, nobody had ever heard of RCOs, and of course the Grenfell Tower fire hadn't taken place. And the mischief of an RCO from SVDP's point of view is that neither SVDP nor EVML can pursue claims against contractors and consultants at the same time and in the same forum as it might in TCC proceedings. TCC, Technology and Construction Court. And so the risk landscape that existed back in 2011 changed long after the event. So if this claim had come up in 2011, someone, maybe a group of leaseholders, would have sued SVDP as the developer. SVDP would have brought in Galliford Try as the design and build contractor, and then Galliford Try, no doubt, would have brought in the architect, maybe the fire engineer, whoever else. And then that claim would wend its way through the High Court process. Most likely it would settle. If it didn't settle, it would come to judgment. But the developer would have got all the proceeds of the litigation before having to pay over money. But of course, the effect of an RCO is to cut through that whole process. And understandably so, if you need the money to get work done. But if the work is being done, we say it's not just and equitable to make the developer pay first before opportunity's been had to follow through on the claims that it has down the line. Now, just one point. It's said by my learned friends at paragraph 50 of their skeleton that SVDP is not understood to have done anything about its rights against third parties in the period since the FTT's decision. That's page 66 of the bundle. I should say that's not correct. If you want details, I can give them to you. But as a headline, a pre-action protocol letter of claim was sent by SVDP to Galliford Try on the 18th of September 24. Galliford Try responded on the 29th of November, and they've also attended several intrusive site inspections in January of this year. Just picking up on a point that I made earlier, the claim will include claims relating to internal compartmentation and fire stopping defects, which are the subject of investigations which EVML has been carrying out. Once SVDP has the necessary survey reports, it can fully progress this aspect of its claim.
Sorry, it was fire stopping defects, and what else did you say it included?
Well, it would include the remedial works
Yes.
that we know about, the external
Yes,
walls,
quite.
but also internal fire stopping works.
Yeah, and sorry, I thought as you were saying it, there was another category that as well. But it doesn't matter.
Oh, sorry, I said internal compartmentation and fire stopping defects. At a fire engineering level, there's a difference between the two. Probably for your purposes, they're both internal compartmentation defects.
Yes, I see.
And as I've already said, the BSF funding doesn't cover the internal defects. Ground 1.6. So, just to introduce this ground, I'm going to canter through some of the relevant paragraphs of the judgment, which contains the findings of fact. The application to the BSF was made at Triathlon's request. See paragraph 191 of the judgment. The story behind how the remedial schemes for each of the 5 blocks were arrived at is summarised at paragraphs 194 to 198, which record that SVDP or Get Living wanted to explore less expensive remedial options, but the remedial schemes implemented were the only schemes that would be eligible for funding from the Building Safety Fund. And then paragraphs 200, 201 and 206 of the judgment...
Sorry, 200?
Sorry, 200, 201 and 206.
Thank you.
Get Living and Triathlon worked together to obtain the funding. there was never anything which suggested that funding would not be provided, but the tribunal has not given any consideration to these points when carrying out the just and equitable balancing exercise, despite the fact that Triathlon was party to the applications for RCOs. We say that the tribunal was wrong in doing so because when an issue is whether the public purse should be the forward funder of the remediation works, it must be relevant to the just and equitable question that applicant for the RCOs, Triathlon, has been party to and a supporter of the funding application. That in effect Triathlon now says we cannot rely upon in opposing the RCOs. In my submission, the just and equitable requirement requires all relevant facts to be taken into account. And when two parties have worked together to arrive at a remedial scheme and to obtain funding for that scheme, it's not just and equitable for one of those parties to then say that the existence of that funding, which they agreed to obtain, should be disregarded. And this is not a case, as is suggested by Triathlon at paragraph 54 of their skeleton, where my clients are, and this is their phrase, railing against the fundamental changes introduced by the Building Safety Act. If you're looking that up, my lord, it's page 67. This is a case where SVDP and Get Living is railing against Triathlon using the Building Safety Act against it only after the parties were well down the road to obtaining full funding, and only after Triathlon had obtained what it wanted, which was its full remedial scheme at no cost to Triathlon. My lord, I then come on to ground 1.7. And I saw a look up at the clock, and it's...
Now you've got a few moments. Or would you think this is a convenient moment?
Well, we could either stop early and start early, or...
How long will ground 1.7 take?
It might be more like 10 minutes rather than 5, but it's...
Shall we do ground 1.7?
Yes. So, for this purpose, can I ask you to look at paragraph 273 of the judgment, which is at page 202 of the core bundle. So, I'm sorry.
Yes.
There's 2 points in this paragraph, so I'm actually going to deal with 1.7 and 1.9 together.
Yes.
The first point is the line, the second sentence, no evidence to suggest that the fund expected Get Living to forward fund the work or that its continuing support was dependent on the outcome of these applications. That's ground 1.7. Or the number ground 1.7. And then what's ground 1.9 is the next sentence where I refer to grant funding agreement prohibiting EVML from pursuing the claims, and they say that's the optimistic interpretation. I'll deal with them together because they're in the same paragraph and they both require consideration of the grant funding agreement. But my headlines are that those points are not neutral. Our interpretation of the GFA was not optimistic, and these points are matters which should be given weight, because the 2 points go directly to the question of whether it's just and equitable for money to be ordered to be paid out of Get Living's bank account. If the Secretary of State or the administrators of the fund were positively chasing for the money, surely that would be a point against me. But if they're not chasing for the money, that should be a point in my favour. It can't be neutral in my submission. And as I've already said, the terms on which the funding has been advanced need to be considered. We've already looked at clause 5.4, and you have the point that it envisages a 12-year horizon for recoveries. It doesn't show that the public purse is only to bear the cost of remediation as a last resort. Rather, it demonstrates a clear willingness of the public purse to forward fund the remedial works, with reimbursement through the pursuit of reasonable remedies later down the track. That's 5.4. Let me just take you to the other provisions. So back to the supplemental bundle, and you'll remember it was behind divider E, section E, tab 3. And if I can ask you please just to turn to page 193 in the recitals. And for these tabs, actually to look at recital E, where they record how DLUC and the GLA are providing the funding to the applicant, irrespective of any restrictions or protections introduced or imposed by the Building Safety Act in relation to any leaseholder that is a protected leaseholder. A protected leaseholder it is defined at page 207 as someone who holds a qualifying lease. I know you're familiar with the concept of qualifying lease now. And we've already talked about the protections. We say those protections include section 124. And they also include the prohibition in Schedule 8, paragraph 2, on service charges being payable where the landlord is the developer or an associate of the developer. So this recital shows that the funding was being provided irrespective of the position under Schedule 8, paragraph 2. And it's clearly in my submission the role of DLUC and the GLA to determine whether or not it's in the public interest to fund the remediation works on the terms of the GFA. It's made that decision, and there's no public law challenge to that decision. And we submit that it's not the role of the courts on an application under section 124 to second guess what's in the public interest by going beyond what the terms of the funding require. And that's because, as we say at paragraph 65 of our skeleton, the public interest is rarely clear-cut. There are defects which aren't covered by BSF funding. And just as we have a building safety crisis, we also have a national housing shortage. And so a balance needs to be struck, because the harder you hit developers and people in the industry for the cost of rectifying existing buildings, the less money they will have available to them to fund the remediation of defects that are not funded by the Building Safety Fund, or to fund the construction of new housing. That, in my submission, is a balance that is plainly one for politicians rather than the courts. Put it another way, the court should be very, very slow to upset the bargain struck with the public. And then moving on to the point for ground 1.9, we have clause 4.3.1 brackets D, which is moving on in the agreement at page 218.
Sorry, can you give the reference again?
Yes, page 218 of the supplemental bundle.
Thank you.
It's clause 4.3.1 brackets D. So just start with 4.3.1. It's an undertaking and warranty by the applicant, so EVML, to DLUC and the GLA that, and then perhaps you should just read D for yourself. So what you see is that this clause expressly precludes EVML from claiming the cost of remedial works from any leaseholder, irrespective of whether they are a protected leaseholder or not. And note that it gives the leaseholder third-party rights. So even if DLUC or the GLA has no interest in enforcing the clause, the leaseholder can do so. And if Get Living is a leaseholder, it can enforce the clause. Now, so you need to understand the definition of leaseholder, and that's at page 204 of the bundle. You'll see it's the second defined term from the bottom. And the particular elements of the definition are A and B for these purposes. First is a person that's party to a lease document, and the second is B, any person that controls any person other than the applicant that is a party to a lease document. And then you see the definition of control underneath, power to direct the management and policies of an entity, whether through the ownership of voting capital, by contract, or otherwise. So you see it's not just parties to a lease document, it's anyone who controls such parties. And Get Living is such a person. I can take you through the detail of that, but I don't think it's controversial, so I won't, unless I have to by way of reply. So we say the Building Safety Fund, through the grant funding agreement, positively precludes EVML from claiming the remedial costs from Get Living. And actually SVDP. I'd have to check SVDP, but certainly from Get Living. Now, I recognise that our interpretation of that clause, 4.3.1, is disputed. But I have to say I don't understand the argument, because what seems to be relied upon is the context of something to displace what is the clear language of the clause. So I'll deal with that in my reply submissions.
Can it be waived by the department and the GLA?
That is a point that is also made, and there is a restriction under the Third Party Rights Act, but in any event, there is no suggestion that would be speculative. There's been never any suggestion that obligation is being waived, and of course we know how the Secretary of State has been following this litigation. And my submission in this context is the tribunal was wrong when they said my interpretation was optimistic. No, my interpretation is correct. But two, so what? And I say this: if EVML cannot claim the remedial costs from Get Living, it cannot be just and equitable that Triathlon, whose directors authorised EVML to enter into the grant funding agreement, can do so either. Or to put it another way, going back to ground 1.2 and the LPI regs, if it's relevant that EVML has an unanswerable claim against the freeholder, it must also be relevant that Get Living has an unanswerable claim against EVML. It's got to be a consistency of approach. And that follows through because the tribunal gave weight to the fact that EVML supported Triathlon's application. And that's paragraphs 248 and 288 of the judgment. But if they're to place weight on EVML's support, it should also place weight on the fact that in giving such support, EVML is in breach of the grant funding agreement. So my Lord, I think I might have gone a bit longer than I advertised.
But we've done the two points.
Yes, and we are on time.
So if we come back at 2:10, we'll
Yes.
still be on time. We'll do that.
Well,